Hi, I am attorney Desiree Koger-Gustafson with Immigration for Couples. And today we are going to discuss the waiver overview process and how to plan for success. What is a waiver? A lot of people have heard just that term, but don't really understand what that is. So we're going to just kind of briefly go over an overview of what that is today. And then in future sessions this week and maybe next week as well, going into some of the waivers that we see regularly in more detail. So as you might be aware, today the test for entry into the United States is whether or not a foreign national has been lawfully admitted. And what does that really mean? Well, in the Immigration and Nationality Act, more commonly referred to as the INA, there is a laundry list of what we call grounds of inadmissibility. Now, these would be grounds that are spelled out where a foreign national is unable to seek admission or legal status into the U.S. based on a prior bad act or wrongdoing on that foreign national's behalf. And so there are several different types. There's 8 or 9 types of general grounds of inadmissibility for a foreign national to enter the United States or seek legal status. The first one, and some of these others are probably pretty common sense, but the first one would be criminal or conviction-related grounds. These could be certain what they term as crimes of moral turpitude, convictions, certain convictions, or convictions that are 2 or more can kind of be taken as a totality of the circumstances. Drug abusers, those are just a few of the criminal-related grounds. There are health-related grounds, and these will be discussed in a separate section when we talk about the medical exam itself. But essentially, they're looking for 4 different things, 2 of the most common ones being communicable diseases and mental health. So they're looking at whether or not that person poses a risk for either of those 2 reasons to the people in the United States. The third is one of the most common grounds of inadmissibility that I see, and that is misrepresentation grounds. And this could be anyone who has received a visa or is seeking a visa or other documentation or other admission into the United States, and they do so by either fraud or willful misrepresentation. Something of a material fact in that caused them to then get their visa. It can include someone who has falsely represented himself or herself to be a United States citizen. So that's just really a lot. I've seen that in, birth certificates or things that have been marriage certificates that have been given to a consular, and the consular has basically said that certificate itself was fraudulent. So that's where that comes into play. It's probably the second most frequented ground that I do see. The fourth ground would be public charge ground, and this one has been discussed recently in one of our Facebook Live videos by attorney Vanessa, and can be overcome, but it is looking at whether or not the household makes enough money to be able to support that immigrant who is intending on immigrating to the U.S. There are security and foreign policy related grounds, so these would be terrorist-related grounds. There's also stowaways and smugglers grounds, which I have seen quite a bit as well. And then probably the most frequently one that I see is the unlawful presence. And there's a whole determination based on what starts and stops that unlawful presence grounds. But if you came without an inspection by a Border Patrol agent, or if you overstayed your visa and you're above the age of 18, it's likely that you might have some unlawful presence and need a waiver. There's also the 3 and 10-year bars, and those are fairly significant bars. And if you have heard that terminology, or you know that you are in that category, you likely know what the 3 and 10-year bar means. but it is a serious ground of inadmissibility. And something too that I would say, if you think you might have that or that might apply to you, definitely seek assistance from counsel. And then there are some miscellaneous grounds. So those are all of the inadmissibility grounds laid out in the INA, or the Immigration and Naturalization Act. There is also the INA provides broad authority to the U.S. Department of Homeland Security to waive most of those grounds of inadmissibility, but not all. So it's not all-inclusive. So while that means that a waiver might be available, that does not mean that there is a standard by which that waiver is going to come by. So there's a lot of nuances and storytelling and putting your waiver in the best light. Again, planning for success when you file for one of those. So I really would encourage, if you feel like you might need a waiver, and you'll be able to watch some live videos coming up throughout this week and beginning of next week possibly, that would give you some more information to let you know, okay, red flag, I probably might need a waiver, and I should probably seek assistance of counsel to have somebody help you advocate, because there is no standard for that. It's not like fraud, where it says, it lays out 4 different ways to prove that somebody has committed fraud. There is no standard for the waiver. So there's a lot of storytelling and a lot of just advocating and knowing what things to put into a waiver for you to put that in the best light to help you plan for success. Sometimes whether or not a waiver is available really depends on the relationship to the U.S. citizen, and then other times it doesn't. So again, lots of nuances within the practice of waivers. In general, a person within Department of Homeland Security, the agent, is going to be looking at the risk of harm in admitting that person. And if there isn't really, that would weigh in that immigrant's favor. Sometimes they would look at the seriousness of the inadmissibility acts. A lot of times here we're talking about the criminal related grounds. Sometimes they'll look at the hardship to the U.S. citizen. So the extreme hardship sometimes is that threshold that we want to meet in laying out whether or not somebody is a good candidate for a waiver. And then sometimes they do also look at rehabilitation. Again, that would be something that would fall into the criminal related grounds a lot as well. So this has kind of been just an overview of the waiver process. And again, it starts with those grounds of inadmissibility and whether or not we need to overcome those grounds in order to be able to either get the visa or legally adjust status for that immigrant here in the United States. So thank you so much. Have a great day.